start. Thanks for coming out today through the rain and lunch formation and all that stuff that you have to do, especially coming off Forestall last night. I was thinking about this today. I study history, and it's a wonderful thing to study Southeast Asian history, but it's another thing entirely to do something about it. And the speaker we have today is someone who studies history and then does something about it. Political scientist Dr. Craig Etcheson is a visiting scholar with the School of Conflict and Analysis and Resolution at George Mason University. He's a specialist on transitional justice. Right now he's completing a book on the interaction of law and politics in war crimes tribunals. And as part of this, from 2006 to 2012, working for the United Nations, he was an investigator in the office of the co-prosecutors at the extraordinary chambers in the courts of Cambodia, and he'll tell you about that today. He's taught at Northern Illinois University, George Washington University, Johns Hopkins, Yale, and USC. He's the author of multiple books, including The Rise and Demise of Democratic Kampuchea, Reconciliation in Cambodia, Theory and Practice, and After the Killing Fields, Lessons from the Cambodian Genocide. He's going to talk for about, well, I should also point out his biography. He used to be my boss. He was my boss 20 years ago, back before either of us had gray facial hair. And actually, I think about it, even before we had any facial hair. So I'm thrilled to be able to host him today. Please join me in welcoming Dr. Craig Etcheson.
Thanks for that kind introduction, Rick, and thanks to you and your colleagues at the Center for Regional Studies for having me in to speak with you today. I'm particularly excited to be here because my own dad was an old sea dog. He enrolled in the Navy Air Corps while in high school during World War II and ended up getting his commission at Columbia University in New York. After more training at Purdue University and the Navy War College in Newport, he finally got to go to sea. So, even though he did not go to school here, he understands well how Naptown can funk you up. But enough of that. Let's get down to business. And my business is war criminals. I travel a lot. And when I re-enter the U.S., the border control people always ask me, business or pleasure? And I say, business. And they say, and what is your business? Attempting to summarize a complex reality, I usually say, I hunt war criminals. That elicits some interesting responses from the border agents, but it's a reasonable shorthand for what I do. Of course, I don't hunt war criminals with guns. I try to leave the kinetic stuff to the professional shooters. I hunt them with information, and I hunt them with political savvy. There's an old saying among people who do what I do. Murder one person, go to jail. Murder 10 people, go to an insane asylum. Murder 100,000 people, get invited to a peace conference. That's supposed to be a joke, but it really does reflect an underlying truth. It typically takes quite a substantial political and military infrastructure to murder 100,000 people. And once one has that sort of infrastructure, one is not so easily trifled with. No doubt you've heard of the International Criminal Tribunal for the former Yugoslavia and numerous other internationalized courts that have been prosecuting war criminals. But the truth is that establishing a judicial mechanism to bring major war criminals to trial is an exceedingly complex undertaking, and it's exceedingly rare for that to happen. There are perpetrators of massive atrocities running around all over the world who, for one reason or another, have nothing to worry about. Bringing war criminals to justice is harder than it looks. To illustrate this elemental fact, today I'm going to talk to you about one particular instance in which we did manage to arrange the establishment of a war crimes court. It is an instance that I know something about because I've been working on it for 25 years, and it's still not done. And the results so far have been, it's fair to say, not entirely satisfactory. This is the case of Cambodia and the Khmer Rouge. The events in question happened before most of you were born. On April 17, 1975, at the climax of a vicious 5-year civil war, a guerrilla movement led by the Communist Party of Cambodia seized the capital of Cambodia, Phnom Penh. They had defeated a Western-oriented Republican government that was a client of the United States. These communists implemented what many analysts argue was the most totalitarian regime in the history of mankind. On that first day, April 17, 1975, they emptied Phnom Penh, millions of people in all, and forced everyone to march into the countryside where they were to hack new settlements out of the jungle. But on the 4 major roads leading out of Phnom Penh, checkpoints were set up, and anybody who looked like a soldier or an officer was pulled out from the streaming mass of evacuees, marched off into the bushes, and summarily executed. The major provincial capitals, Battambang, Pursat, Siem Reap, Dachau, and others, fell in the next few days, but the Khmer Rouge tactics were a little bit different there. Republican commanders were told to gather their entire officer corps, to wear their finest dress uniforms, so they could all be taken to greet the returning Prince Sihanouk, the former king of Cambodia. They went proudly and happily in their thousands, trucked to execution sites where they were systematically slaughtered. In the succeeding weeks and months, Cambodia was transformed into a gigantic slave labor site, a prison without walls, as the entire population was put to work. The Khmer Rouge abolished family, money, markets, religion, schools, modern health care, and most other aspects of life that give coherence to the people. There was only one authorized activity: grueling manual labor, 12 to 14 hours a day, 7 days a week, on starvation rations. City dwellers, who were unaccustomed to agricultural labor, dropped like flies and were literally converted into fertilizer. Anyone who protested these conditions was summarily executed. Most anyone with an education, doctors, lawyers, bankers, merchants, students, and so on, was hunted down and killed. The population of Cambodia, when the Khmer Rouge took over, was something on the order of 7.5 million. The Khmer Rouge regime lasted only 3 years, 8 months, and 20 days. But in that brief time, somewhere between 1.7 and 2.2 million Cambodians lost their lives, or more than 1 of every 4 people. They were also bad neighbors. The Khmer Rouge launched military attacks on all 3 neighboring countries: Thailand, Laos, and Vietnam. After several years, the Vietnamese decided that they had had enough. In December 1978, the Vietnamese invaded with a massive force on the order of 3 corps. Within 2 weeks, they had seized the Cambodian capital and forced the Rump Khmer Rouge forces over the border into Thailand. Well, you might think that Thailand wouldn't like that idea very much. But if there's one thing that the Thais liked less than the Khmer Rouge, it was the Vietnamese. And now the army of that traditional rival was hard up against the Thai border. And the Chinese, who had been the only major ally of the Khmer Rouge, rapidly rearmed the Khmer Rouge army. You may also recall that at this time, 1979, the U.S. was working to improve relations with China. In fact, resuming diplomatic relations on January 1, 1979. Of course, only 4 years previously, the North Vietnamese had inflicted perhaps the most humiliating defeat in the history of the United States. So the Cambodia situation quickly became something upon which the United States and China could see eye to eye. The Chinese and the administration of President Jimmy Carter quickly assembled a coalition which arranged for the Khmer Rouge to retain the Cambodian seat at the United Nations, even though the Khmer Rouge no longer controlled the country, and even as it was clear to anyone who cared to look that the Khmer Rouge were genocidal maniacs. That same year, 1979, Ronald Reagan won the presidency, and he and his team solidified and extended these initial moves by Carter. In Angola, Afghanistan, Nicaragua, and Cambodia, the Reagan administration supported insurgencies against Soviet client states. This policy became known as the Reagan Doctrine. The Reagan Doctrine aimed to increase costs for the Soviet Union, and if possible, to overthrow those client states and replace them with regimes that were no longer hostile to the United States. In Cambodia, the Khmer Rouge would benefit greatly from the Reagan Doctrine. This constellation of geopolitical interests set in motion a dynamic which would result in another 20 years of war in Cambodia. Even so, in 1979, barely 9 months after the overthrow of the Khmer Rouge regime, the new Cambodian government held a trial known as the People's Revolutionary Tribunal. They convicted top Khmer Rouge leader Pol Pot and Khmer Rouge Deputy Prime Minister and Foreign Minister Ieng Sary, sentencing them to death. It was, however, an in absentia trial, since Pol Pot and Ieng Sary were busy rebuilding their international alliances and their army for a long war of attrition against the Vietnamese and the regime Vietnam had installed in Phnom Penh. As it happened, though, the People's Revolutionary Tribunal was a brisk and well-orchestrated affair, lasting scarcely 5 days, including the opening and closing banquets. Pol Pot's defense attorney filed a complaint with the court, accusing his own client of genocide. The president of the court, whose day job was Minister of Propaganda, also announced the verdict before the trial actually started. For many people, including many Cambodians, all of this didn't really look much like justice. Now, one of the odd things about the Khmer Rouge regime was their policy of radical autarky. That is, they believed that the less contact with the outside world, the better. Inside Cambodia, absolute secrecy in all things was ruthlessly enforced. So there was no mail service, no international telephone lines, no newspapers, no TV. Radio was only for senior communist cadres, and the only radio station was the communists' own radio station. The only international trade to speak of was with China, in which Cambodia traded agricultural products for weapons. The only way in or out of Cambodia was through the once-a-week flight to Beijing. As a result, it was hard for the rest of the world to tell exactly what was going on inside Cambodia during this period. A handful of refugees who escaped told incredible tales of horror, which were really kind of hard to believe. That all changed when the Khmer Rouge were driven from power by the Vietnamese. International relief workers, diplomats, and journalists began to trickle in, and the unprecedented scale of the trauma that Cambodians had suffered soon became clear to the outside world. Two such individuals were an American missionary named Greg Stanton and an American human rights activist named David Hawk. Appalled at the extent of the slaughter, Stanton and Hawk began collecting evidence of the crimes. They went on to form two organizations, Stanton's Cambodian Genocide Project and Hawk's Cambodian Documentation Commission. Both spent most of the 1980s lobbying the world's powers to bring the Khmer Rouge leadership to trial for war crimes, genocide, and other crimes against humanity. But the world's great powers had other ideas. The US, China, and their respective allies were backing an exile coalition dominated by the Khmer Rouge. The Soviet Union, Vietnam, and their allies backed the new Cambodian regime. As a result, everybody settled in for what became a long war of attrition. A popular saying in those days had it that the strategic issues at stake in Cambodia were of such supreme importance to the world's powers that both sides were willing to fight to the last Cambodian. Fortunately, it didn't turn out that way. By 1989, the Soviet Union was beginning to collapse, and the Soviets started to withdraw support from their Third World allies, including Vietnam. Vietnam, in turn, began to pull out its forces from Cambodia, hoping that its client state was strong enough to survive on its own. Since the withdrawal of Vietnamese forces from Cambodia was the principal Chinese and American demand, an opening appeared for a negotiated solution. After 10 years of fruitless struggle, the great powers were ready to make a deal, whether their respective Cambodian allies liked it or not. Several years of tough negotiations in Southeast Asia and then in France culminated in the Paris Peace Accords of 23 October 1991. This deal set up what was to be the largest and most interventionist United Nations peacekeeping operation in history. There were 4 major Cambodian factions: the incumbent government in Phnom Penh, the Khmer Rouge, the remnants of the 1970-75 Republican government, and a 4th faction representing Cambodia's royal family. In theory, the UN would take control of Cambodia, disarm all 4 armies, and organize a free and fair election through which the Cambodian people would choose their path to the future. In practice, it didn't quite turn out that way. The Khmer Rouge refused to disarm, and so the peacekeeping mission became an election-holding mission, though they did that quite well. The result was a coalition government of 3 factions, with the Khmer Rouge the odd man out. It was the beginning of the end for the Khmer Rouge, but it would take nearly another decade to eliminate their army through combat and defections. While all of this was going on in Cambodia, a group of activists in Washington, D.C. decided to launch a new gambit for an international tribunal. The Paris peace deal was premised upon the establishment of a legitimate regime operating under the rule of law. We thought that laws on genocide should be part of that deal. With New York's Stephen Solars in the House of Representatives and Virginia's Chuck Robb in the Senate, these activists pushed legislation which would make it U.S. policy to support a tribunal for the Khmer Rouge. But there was a problem. The U.S. State Department feared that the tribunal plan secretly aimed to make trouble for former Secretary of State Henry Kissinger. So the U.S. government was firmly opposed to this idea. Thus, the first task was a major change in U.S. policy. Make no mistake about it, this was a knockdown, drag-out political struggle. That process took 3 years until finally, in 1994, President Clinton signed the Cambodian Genocide Justice Act. It was now U.S. policy to support a Khmer Rouge tribunal. That legislation also provided funding for research on what happened in Cambodia under the Khmer Rouge. An initiative was soon established at Yale University under the auspices of the Cambodian Genocide Program, or CGP. The CGP set out to implement a 3-prong mandate of training, research, and documentation. For the training prong, CGP trained young Cambodian legal students in human rights, international humanitarian law, and international criminal law. For the research prong, we aimed to create a set of studies examining what happened in each different region of Cambodia under the Khmer Rouge. And for the documentation prong, CGP's agreement with the State Department called for a database of all primary documents relating to the Khmer Rouge rule in Cambodia. we decided to take that part of the project further, creating not one, but 4 databases. A bibliographic database of books, documents, and other printed materials, a biographical database of Khmer Rouge cadres, victims, and other persons of interest, a photographic database of still, film, and video images, and a geographic database of maps. Then we mounted all of those databases on the web, creating a portal so people anywhere could access those databases. Now, I'm sure that seems like no big deal to you today, but 20 years ago, that was a revolutionary idea about the kind of content that might be interesting to put online. Because most of CGP's research was done in Cambodia, we established a field office in Phnom Penh called the Documentation Center of Cambodia. We set the Documentation Center up in such a way that once the Yale program ceased operations, the Documentation Center would continue as an independent Cambodian research institute. I am proud to say that 20 years later, the Documentation Center is going stronger than ever, continuing to crank out original research and many other interesting projects. One notable Documentation Center project, for example, was the Mass Grave Mapping Project. Over the course of 10 years of field work, mass grave mapping teams discovered more than 20,000 mass graves dating to the Khmer Rouge period, containing the remains of an estimated 1.1 million victims of execution. In the process, we also mapped a nationwide network of so-called security offices, where those more than 1 million victims were interrogated and tortured before they were executed. Prior to this project, the existence of this elaborate network of torture centers was unknown to researchers. While we beavered away on the Cambodian Genocide Program mandate, new moves were afoot within the U.S. government. The State Department established an Office of War Crimes Initiatives, and its first leader, Ambassador David Sheffer, set about trying to find ways to establish a tribunal for the Khmer Rouge. A parallel effort was underway among a handful of United Nations officials. The Secretary General's Special Representative for Human Rights in Cambodia, the Swedish diplomat Thomas Hammarberg, arranged for a United Nations group of experts to prepare a report on Cambodia, examining whether and how the Khmer Rouge could be brought to justice. This, in turn, led to a nearly decade-long negotiation among the UN, the Cambodian government, and a variety of interested states. Finally, in July 2006, a new breed of internationalized criminal tribunal was established. It is formally known as the Extraordinary Chambers in the Courts of Cambodia, or more commonly known as the Khmer Rouge Tribunal, or KRT. The new court would be based in Cambodia and have a majority of Cambodian judges, with international officials filling out a minority of the judicial staff. It would also have 2 prosecutors, one Cambodian and one international, as well as 2 investigating judges. The KRT was tasked to try senior Khmer Rouge leaders and those most responsible for the most serious atrocities between 1975 and 1979. The court would seek to charge the accused with war crimes, genocide, and other crimes against humanity. It was the first court of its type to be attempted, and in many respects was, and still is, very much an experiment. Coming more than a quarter century after the crimes were committed, moreover, many of those whom it might have prosecuted, including Pol Pot himself, were already dead. In mid-June 2006, newly appointed international co-prosecutor Robert Petit asked me to help him establish his office and to lead the investigations for the KRT. We arrived in Phnom Penh at the end of June. The first task facing the senior players at the court was to figure out how they were going to make this thing happen. The general structure of the court was laid out in an agreement between the UN and the Cambodian government. But exactly what laws would this new court use? What legal procedures would apply? If anything, Cambodia had all too many laws, with 50 years worth of legal codes promulgated under 6 different regimes. In practice, Cambodian courts tended to apply all of these laws willy-nilly with no apparent rhyme or reason. None of these domestic laws dealt adequately with the international criminal charges which were contemplated for use at the Khmer Rouge Tribunal, such as genocide and crimes against humanity. Moreover, nothing in Cambodian law or legal procedure contemplated structures such as co-prosecutors and co-investigating judges, or crimes as complex as those alleged to have been committed during the Khmer Rouge regime. Clearly, we had some heavy lifting to do before anyone would be able to understand exactly what law applied at the Khmer Rouge Tribunal. So, on July 3, 2006, the KRT convened an initial week-long judicial conference to begin addressing these and other issues which would have to be sorted out before we could really get down to the business of prosecuting war criminals. The national and international co-prosecutors, judges, and top administrators, along with the handful of staff that had been thus far recruited, gathered at a hotel in Phnom Penh to start work. One result of that first week of plenary meetings was recognition that the court was going to need its own unique set of rules to deal with the unique structure of the court. The UN Cambodia Tribunal Agreement specified that the court should use existing procedures in force in Cambodia, except in the case of conflict with international standards. Determining exactly what Cambodian procedures were in force and exactly what constituted international standards would not be a simple matter. In the end, it took nearly a year to hammer out a set of internal rules for the court. The greatest bulk of this time was required simply because it is an enormously complicated undertaking to create a framework for an internationalized court. The Khmer Rouge Tribunal brought together judges and prosecutors from a dozen different jurisdictions, each of whom had his or her own ideas about how things should be done, and all of whom thought he or she was right. The court has lots of moving parts: the co-prosecutors, the co-investigating judges, the defendants, the civil parties, the victims, witnesses, the pretrial, trial, and appellate chambers, and a complicated administrative apparatus to support all those parts. All of these parts have to fit together precisely, and to do so in unforeseeable circumstances while accommodating a bewildering array of legal and technical issues. The Khmer Rouge Tribunal was also the first internationalized court to be based primarily on continental-style civil law procedures, as opposed to the British common law procedures employed by its sister international criminal tribunals. And of course, everything had to be done in all 3 of the court's official languages: Khmer, English, and French. All of this added up to a real challenge for the Rules Committee. In retrospect, it's surprising that they got the rules sorted out as quickly as they did. The resulting rules, however, created a complex and, it seems to me, unnecessarily repetitive process. Many of the legal issues which come before the Khmer Rouge Tribunal are litigated not once, not twice, not 3 times, but 4 times. First by the co-investigating judges, then by the pretrial chamber, then by the trial chamber, and finally by the Supreme Chamber. This is an extraordinarily time-consuming process, particularly in view of the fact that there are scores and scores of issues which are ultimately litigated. Not to mention the fact that everything had to be done in 3 languages. To further complicate matters, for each case, the process of preparing accusations against the suspects is carried out 3 different times. First, the co-prosecutors conduct a preliminary investigation and then prepare a document known as an introductory submission. In effect, this is an indictment, and it is not a simple document. The first introductory submission was tens of thousands of pages long. In hard copy, it filled up more than 100 binders, each up to 500 pages long. Upon receiving the introductory submission, the co-investigating judges then conduct another investigation known as the Judicial Investigation. At the conclusion of the Judicial Investigation, the co-prosecutors prepare another document known as the Final Submission. This is a second indictment which takes into account any new information turned up during the judicial investigation. With the final submission in hand, the co-investigating judges then produce a document known as a closing order, which is the third and final indictment and the one that the prosecution is charged to carry into the courtroom. Is it really necessary to go through this process 3 times? It's time-consuming enough to do it just once. Well, while the rules-making process proceeded in 2006 and early 2007, we in the Office of Co-Prosecutors launched a preliminary investigation. This was a complex challenge in and of itself. Major crimes were committed everywhere in democratic Kampuchea, every day, for the 3 years, 8 months, and 20 days of the regime. As National Co-Prosecutor Chea Liang asked me early on, how do you investigate 2 million murders? Well, the answer, of course, is that you don't, not unless you have several lifetimes to get it done. Instead, what we did was to first identify the patterns of violence, which can be construed as criminal. Then we analyzed those patterns to find instances of each particular type of violence, which were typical, and for which there was, or was likely to be, compelling evidence. The third analytical layer was to identify who was responsible for those episodes of violence, and then to locate evidence linking those individuals to that violence. This investigative methodology turned out to be troubling to our Cambodian colleagues. Our approach was basically the inverse of the way Cambodian prosecutors do it. In a typical Cambodian criminal investigation, usually the prosecutors identify a suspect, decide what charges to bring against the suspect, and then obtain a confession to those crimes from that suspect. Case closed. Thus, they regarded our approach as unnecessarily complicated. But for our part, the internationals in the Office of Co-Prosecutors insisted that we needed to understand the violence itself before we accused individuals of complicity in that violence. Consequently, we examined the involvement of many, many individuals all over the country. To give you a sense of the granularity of our investigation, one project I launched was to create an organization chart for the entire Communist Party of Kampuchea, from the Standing Committee and the Central Committee down through the zone committees, the sector committees, the district committees, and the commune and cooperative committees, along with all of the military and government structures. Needless to say, this process involved identifying many thousands of cadres. As National Co-Prosecutor Chea Liang said to me from time to time, "Too many names, Craig." Well, we wanted the indictment to illustrate the full spectrum of criminality in democratic Kampuchea, so we adopted an approach which was both top-down and bottom-up. First, we identified the 5 or 6 most senior surviving Khmer Rouge leaders for whom we could establish criminal responsibility. This would allow us to demonstrate who devised the policies of the Khmer Rouge regime and ordered those policies to be carried out. This prong of our work would eventually result in what are known as cases 001 and 002. Second, we also aimed to identify 5 or 6 surviving regional leaders who played crucial roles in the typical instances of criminality that we had previously selected. This would allow us to demonstrate how the regime's policies were actually implemented in practice and the consequences of following the top leader's orders. That prong of our work resulted in what are known as cases 003 and 004. Thus, we would end up with 10 to 12 accused persons, which we thought was well within the prosecutorial mandate we had been given. But who would be these suspects? The challenge was to follow the evidence. And this was where, I'm afraid, we completely lost some of our national colleagues. We did in-depth investigations of more than 30 persons of interest, working to discover against whom we could build the most solid cases. That disturbed some of our national colleagues. They began to suspect that we were going to expand the net of accused well beyond the politically agreed number of 10 or so. Nonetheless, national-international cooperation continued. The top-down investigation was easier, in part because there was so much contemporaneous documentation of decision-making by the top leaders. In July 2007, we produced the first introductory submission, naming 5 individuals: Nguyen Chea, who was Deputy Secretary of the Communist Party; Ieng Sary, Deputy Prime Minister, Foreign Minister, and number 3 on the Communist Party's Standing Committee; Khieu Samphan, President of the Presidium of the Khmer Rouge State; Ieng Thiriet, Minister of Social Affairs and also wife of Deputy Prime Minister Ieng Sary; and finally, Kang Kek Ev, alias Doik, the Chief of the Secret Police and the Master of the S-21 Security Office. The co-investigating judges decided to sever this submission into 2 separate cases. The case against Kang Kek Ev, alias Doik, seemed relatively simple, as it essentially involved crimes committed only in Phnom Penh at secret police headquarters. There was also ample documentation from the voluminous archives that Doik had accumulated. So, the judges prioritized Doik and brought him to trial first in what became Case 001. While the Doik case worked its way through the other organs of the court, the investigating judges could then concentrate on the other 4 accused in Case 002. Meanwhile, in the Office of Co-Prosecutors, we continued our preliminary investigations on the other prong of our jurisdiction, the bottom-up cases. We eliminated a few individuals among our persons of interest because there was just not much evidence connecting them with crimes, but that still left a fairly sizable pool of candidates. At this point, I came up with what I called the 100K rule. If I could connect an individual with 100,000 murders, then you met my definition of most responsible, which was one of the 2 prongs of our personal jurisdiction. This metric shortened our list of candidates and also dovetailed with several of the factual situations that we had selected to illustrate the patterns of criminality. By the autumn of 2008, we had assembled all of these pieces into 2 new sets of accusations, which we dubbed cases 003 and 004, targeting 6 individuals for prosecution. But suddenly, there was another problem. The national co-prosecutor refused to support the new cases. She argued that these new cases fell outside the jurisdiction of the court and that they represented an unacceptable threat to national reconciliation. This situation invoked the court's dispute resolution procedure, which is decided by the pretrial chamber. For its part, the pretrial chamber split along national-international lines, the national judges agreeing with the national co-prosecutor, the international judges agreeing with the international co-prosecutor. But because the pretrial chamber did not achieve a supermajority to stop the cases, the rules of procedure provided that the new cases would go forward to the Office of Co-Investigating Judges for judicial investigation. On September 9, 2009, 3 weeks after the pretrial chamber ordered cases 003 and 004 sent for judicial investigation, Cambodia's Prime Minister, Hun Sen, delivered a public address in which he announced that he would not permit the new cases to go forward. Some people regarded that controversial speech as political interference in the administration of justice. The government and the ruling party subsequently insisted that it was merely the Prime Minister expressing his personal opinion. Be that as it may, 6 years later, cases 003 and 004 basically remained stuck in the mud. While all of this was unfolding, the Duch trial was completed during 2009, and the trial chamber delivered its judgment in July 2010. The defense, the prosecution, and the civil parties all appealed the judgment, with hearings in the Supreme Chamber during the first half of 2011. Not until February 2012 did the Supreme Chamber hand down their final judgment against Duch. Life in prison. There are a lot more details on that, but I will summarize it by noting that most legal observers seem to think that the Duch trial went fairly well, all in all. On 15 September 2010, more than 3 years after the co-prosecutors filed charges against the accused, the co-investigating judges issued their indictment in case 002. Why so long? There are two main reasons. First, it is in the interests of the defense to string these things out as long as possible. If their clients die before the court reaches a final judgment, then they win with their client's presumption of innocence intact. That has already turned out to be the case for Ng Suri. So the defense lawyers take advantage of every conceivable procedural step to delay the proceedings. For example, the 4 defense teams in case 002 sought to disqualify the co-prosecutors, and then sought to disqualify the co-prosecutors' investigators, me and my team. They sought to disqualify the co-investigating judges, and then sought to disqualify the co-investigating judges' investigators. They sought to disqualify the judges of the pretrial chamber repeatedly. They sought to disqualify the judges of the trial chamber repeatedly. They sought to disqualify the judges of the Supreme Chamber repeatedly. They sought to disqualify the court's administrators repeatedly. They even filed lawsuits against Prime Minister Hun Sen and other government officials in Phnom Penh's municipal court. They tried everything they could think of, and they were really quite imaginative. Resolving all of this litigation took a long time. But an even bigger chunk of time was consumed by the investigations. These are, after all, massive crimes. Accordingly, the charges in the indictment are sweeping. They relate to 3 major rounds of forced population transfer. The charges also concern 11 different torture centers in various parts of the country, 6 different forced labor work sites, several large-scale execution sites, and various other crimes against humanity, including gender crimes and the persecution of Buddhists, as well as genocide against the Vietnamese and genocide against the Chams. The indictment also has to deal with a whole host of factual findings, such as the structure of the Communist Party, the Khmer Rouge military, and the Democratic Kampuchea government, and so on. The main text of the closing order in case 002 is 739 pages, not including the annexes, which run to many additional thousands of pages. The bottom line is that case 002 is humongous. Several legal experts have suggested that it is the largest, most complex criminal case ever brought to trial. And when the judges of the trial chamber saw this thing, you could practically hear the judges collectively gasp, "Whoa." The trial chamber concluded it could take years to conduct the entire trial. Given the advanced age and fragile health of the defendants, there was a risk that they all might die before the trial was finished. So, the judges severed the trial into bite-sized pieces, hoping that at least some of the charges could be tried before they all died. With sufficiently small mini-trials, they thought they could work their way through the indictment, piece by piece, each mini-trial lasting perhaps 3 months. They adopted a chronological approach and began with charges concerning the evacuation of Phnom Penh, known as Forced Transfer 1. That mini-trial began in June 2011 and reached closing arguments in October 2013. Thus, the trial chamber miscalculated the time required for each mini-trial by a factor of almost 10, 28 months instead of 3. It took the trial chamber another 9 months to deliver its verdict, which was guilty on all counts of war crimes and crimes against humanity, with life in prison for Nuon Chea and Khieu Sampan. All parties appealed the verdict, and the appellate hearings began just 3 months ago. While we were getting there, one defendant in 002 died, and another was declared unfit for trial due to dementia. That leaves only 2 remaining accused in 002. The second trial for this pair of Khmer Rouge leaders, known as case 002/02, began a year ago and still has a long way to go. In cases 003 and 004, 2 of the original 6 suspects have died since we began. Of the remaining 4, 3 have been charged as of today, although they were charged only by the international co-investigating judge because, surprise, surprise, his national counterpart does not agree that the cases should go forward. Remember, the Prime Minister has vowed that he will not allow those cases to be brought to trial. So that part of the process is a bit of a mess, to put it mildly. The appeal judgment in case 001 was delivered 18 months after the trial chamber judgment. Case 002/01 is much more complex, and having only begun appeal hearings, it is likely that we will be well into 2017 before we see a final judgment from the Supreme Chamber. That would be 6 years after the indictment and 9.5 years after initial accusations by the co-prosecutors. That seems like a long time until you compare it to how long large trials at the Yugoslavia and Rwanda tribunals have taken. In comparison to some of their more complex trials, this is more or less normal. But in comparison to the actuarial odds that these elderly and frail defendants will still be alive for that long, then it is not nearly speedy enough. Then there is case 002/02. That case includes many more allegations, especially the queen of crimes, genocide against the Vietnamese, and genocide against the Cham Muslims. Will we ever see a verdict issued, not even to mention final judgment on those charges, before the remaining accused expire from old age? Stay tuned, ladies and gentlemen. Returning to my theme, this stuff is harder than it looks. Prosecuting war criminals for mass atrocities is inherently suffused with politics from start to finish. It takes time, patience, and dedication. It takes lots of money, and it takes lots of persuasion. Of course, you are dealing with inherently ruthless, vicious people. And I don't mean just the accused. It is not pretty, and you are never going to get perfect results. But it's worth the trouble. I highly recommend it as a career move for people who want to make a difference in this world. Thank you for your attention.
Fantastic. Well, we have time for at least a question or two before you have to scurry to your next class.
Sir, thanks for coming to talk to us today. In Sudan, Omar al-Bashir is still in power despite committing genocide against his people. Is there anything the U.S. government can do to try to bring him to a place where you and your colleagues can try him, or given the current makeup of the U.S. Supreme Council, is that really unlikely for?
Good question. He's actually a serial genocidist, not just in Darfur, but also in Kordofan and the Blue Nile province of Sudan. So he's really a serial genocidist. He's been indicted by the International Criminal Court, and so if they can ever get their hands on him, he will come to trial. But that seems unlikely because as I mentioned, once you have an army big enough to commit genocide, you're a pretty formidable individual, and indeed he is. And in fact, the United States has very complex and highly valued intelligence relationships with that man, so it's unlikely the U.S. will be pushing this very hard anytime soon. Sir.
Yeah, sir. After World War II, when we held the Nuremberg trials, at least my understanding of those trials, they went through pretty quickly, and we were able to get people prosecuted within a decade. So, what's happened between that time frame and how the world is now that makes it so much more difficult to process people?
Well, when you have a gigantic army occupying and controlling an entire continent, it's much easier to round up suspects. Yes, ma'am.
So considering the fact that a lot of defendants might die before the end of the trial, as you mentioned before, are conducting these trials more symbolic as a gesture to say that some sort of justice is trying to be reached than they are effective, considering a lot of them either fall by the wayside altogether or die before justice is given to them?
Yes, it's quite true that these kinds of exercises are very much symbolic. But you have to ask yourself, when millions of people have been murdered, this sort of explodes the boundaries of ordinary human experience, and you have to ask what would constitute justice under those conditions. You know, the ancient Greeks said that justice is giving people what they are due. So what is due to a woman who saw her children and husband tortured and executed before her eyes by unknown people many years ago? In fact, there really is no satisfactory, fully satisfactory instantiation of justice in these kinds of cases, and so you are reduced to attempting to devise symbolic measures that give at least some sense of succor to victims.